Yeah, absolutely, Ursula. I think that's really seen in those results. People seem to be on board with the fact that there's an evolution happening here, and it's changing. And that's probably a really good time to come to you, Laura. I mean, as the employment law expert here, maybe you could just give us a really clear definition of the law, what are the changes, and how they compare to what's already in place and what people will be familiar with.
Yeah, absolutely. So what I'll start with is just a very quick overview of what the existing flexible working regime looks like. So since 2014, all employees with at least 26 weeks of continuous service can make a flexible working request. And as Ursula has said, that request can be about change of location, hours, times of work, and it can be made for any reason as well. So currently only one request can be made each year, but there's nothing preventing an employee from making a request on an informal basis too. When an employee submits a request, now it has to be in writing, it has to state it's an application under the statutory right, it needs to specify the changes applied for and the date the change comes into effect, and it needs to explain what effect, if anything, that the employee thinks the change would have on the employer and how that effect might be dealt with. It also must say whether the employee has previously made a request and when that was. So when an employer gets this, they then need to deal with that request in what we consider a reasonable manner. Now, there's no statutory definition of what reasonable means, but the ACAS Code of Practice and Guidance gives recommendations. So, for example, meeting with the employee if the request can't be approved without discussion, allowing an appeal, and an employee to have a companion to attend any meetings. All of that is really good practice stuff. Now, employers can rely on certain prescribed grounds for refusing requests, which are on my next slide, and there are 8 reasons why they can be refused. And an employer has to tell the employee of the outcome within a 3-month decision period, unless both parties agree to extend time. So that's a kind of a very quick overview of the current position. So what changes have we got on the cards? So the changes to the regime are to firstly require employers to consult with the employee before rejecting their flexible working request. Now that consultation will be to discuss the change, it will be to consider other available options if you don't think that change can be accommodated. It was interesting because during the government's consultation, it was considered whether employers should have to provide written evidence to the employee showing they've considered alternative arrangements when they reject a request. But it was decided this placed too high an admin burden on employers, and so they landed on a consultation obligation instead. So that's why they've arrived at that change. Another change is to reduce the employer's decision-making period to 2 months instead of 3. So you'll have a bit less time to decide a request. But having said that, you can still ask the employee to agree a longer period if you need to. Thirdly, employees will be able to make 2 requests each year instead of 1. Now, the reason for that change is it was felt that circumstances can change quite a lot within 12 months, and so it's fairer to allow 2 requests to be made in that time frame. And then fourthly, they've removed the requirement for the employee to explain the impact of their request and how that impact may be addressed. There were concerns this could lead to unfair treatment, and the government has also noted that if it becomes a day 1 right to request flexible working, this would be difficult for such an employee to answer. So these are the changes that have been incorporated in the Act. This has received royal assent and it's expected to come into force next summer, but we don't have a specific date for this at the moment. Now, in respect of flexible working becoming a day 1 right, this hasn't been included in the Act, but it is expected that the government will introduce secondary legislation at the same time that Act comes into force to also make it a day 1 right to request flexible working. That's down from the 6-month requirement that currently exists. And Labour has also committed to doing this if it wins the next election as well. And we've had quite a few queries on this day 1 right proposal. I mean, during consultation, it was said that it would open up the right to request flexible working to, I think they said 2.2 million more people. I mean, the effect of this right is uncertain, but I do think from a practical point of view, it's more likely that a prospective employee would informally inquire about flexible working during the application process or after receiving a job offer or a bit later on in that employment relationship. And I think if employees do make very early formal requests and it isn't something that you anticipated, then you may want to make full use of the 2-month decision-making period that you've got before you commit to anything, just to give you a bit of leeway on that if you need it. Now, there haven't been any changes to the 8 business reasons for rejecting a request. This was because essentially no clear picture arose from the responses the government received during consultation. Some people said the list was too broad and needed to be narrowed. Others said it should be expanded. Particularly, I think was one of the suggestions was to capture a scenario where there are concerns over employee supervision and collaboration within home working arrangements. And this is something I see crop up quite a lot. It's a common issue for many of my clients. So we're quite surprised to see the government didn't take the chance to expand that list to expressly capture that, but they didn't. The changes are a bit on the minimal side, and they're definitely a step away from making flexible working the default that was in the Conservative Party manifesto. Although the changes may lead to more requests being made, I think it's really important to stress that whether to accept or decline a request remains in the employer's hands. It's still a right to request. It isn't a right to have flexible working. I also thought it worth just very briefly mentioning that consultation has also now taken place on the new ACAS code and guidance to reflect these changes. The proposed changes to the code aren't groundbreaking. They point to a workplace culture that should be more supportive of flexible working arrangements. The code places greater emphasis on exploring alternatives during the consultation meeting where you can't agree a request. It strengthens some of the good practice principles by recommending you proactively give employees the right to appeal the rejection of request. So that's essentially telling them in writing they can do that rather than just accepting an appeal if they make it. It also recommends, even when a request is accepted, a meeting should be held to ensure that all the relevant information is understood. So you meet with the employee anyway. So consultation on that closed on the 6th of September. So we'll wait to see what changes to the code come out from that. And then lastly, I just wanted to cover kind of what's the takeaway from this? What do you need to do now? The first point I wanted to say is that if you've got existing flexible working policies, it's a really good idea to get those updated to reflect these changes when they come into force. Some of my clients are already doing this and kind of getting ahead of the game. And it's also worth organising training for managers as well, just so that they're aware of these changes and then they can deal with the requests, particularly in the more limited time they have available now. So I definitely think that's a worthwhile thing to do.